They're supposedly reading the agreements. I guess that's the issue. They're not reading the contracts. And we are a society that tries to make decisions based on contracts, especially this kind of business. It's a high-risk business for everyone.
Sure.
And so we've got a lot of risk. The general contractors have a lot of risk on these projects. And they've got time demands and constraints they've got to deal with, and they've got to comply with those
Okay,
commitments.
all right. Is it Mr. English?
Mr. Lee,
Mr. Lee, I'm sorry.
I work for English Construction
Okay.
Company. What we see it is a hindrance to our business if we do not have the right of offset. Tyndall, good organization, they are large. Typically, we would bond them, and that way we would not have to worry about offsets. But where it becomes an impediment to small and emerging business that are not able to bond the projects, that are not able to have set-asides or whatever, we are limited because of our risk, because our bonding company requires us to reduce our risk. If we take on a small company who we're trying to help grow to get more, where do big companies come from? They come from small companies. But if I'm limited because of the risk that I take on from a small company, they're doing a great job, but I don't have the right of offset, it's a hindrance to me to want to give them more than one project. Because, again, the small companies, the emerging companies, they're the ones who have to overcome this burden of cash flow, of staying in business. And it's just one of those things. They don't have the resources to bond. English has been in business for over 100 years. We've mentored and brought up hundreds of companies. Again, Tyndall is big, they're responsible. If I have 2 contracts with Tyndall and I did not bond Tyndall for some reason, if they're not paying their suppliers, like the concrete man, then I need to be able to pay him with Tyndall's money if he comes to me. See, I'm not worried about the recourse or about the lien. What we're worried about is it will restrict our ability to work with small developing companies, even if they're good. If they don't have the bonding capacity, they don't have anything. And state law says that we're responsible. Even if they've signed that release of lien that says they've paid their sub or their sub-sub, if they come and prove that they were not paid, yes, I have to pay again.
Well, why would you have to pay, I mean, if you're the general.
Yes,
and
sir.
I'm your sub, and let's say I supply the rebar, and I supply what I'm required to under the contract, you now have it.
Yes.
And I say, here's my invoice for, $100,000, and you say, go to one of my creditors or you find out for some reason that I haven't paid mine.
If that
Supply it.
subcontractor has not paid his sub or his sub-sub, it can be
Right.
multi-tiered.
I know,
Even
but-
if I have a legal document that says that in Virginia, that release of lien still is useless to me if a sub or a sub-sub proves that, hey, Tyndall didn't pay me and I owe Roanoke Cement, they owe them on my project, and I have a bond on that project, and the owner's paid me, even though I paid Tyndall, then I gotta turn around and pay Roanoke Cement. So the general contractor is in a very difficult position. And that would be, if we don't have the right of offset, one, it really impacts the small folks who we're trying to help and give more work to. The larger contractors, like Tyndall, we would have a bond on them anyway. Because they're capable of performing, providing the bond.
All right, any questions from the panel? I guess my question, sir, would be, if you contract for a service and then the service is performed, you gotta pay. And whether or not, there's always,
We do.
there's always gonna be people down, do they pay their employees, do they pay overtime, do they pay their?
That's right.
There's always other people, but you've got to pay what you're owing.
Right, and Virginia law though requires that if any of those people below that first tier sub
Yeah.
have a claim, where do they go? They don't go back to the person who's getting the building, they come back to the general contractor. So, we are in a position where we could have to pay, we may have paid Tyndall, and they didn't pay Roanoke Cement, and I may have to turn around and pay Roanoke Cement, and I don't get any more money from them.
I don't know about that.
It's just, I believe if you check it, you'll see that that's correct.
All right. Any questions from the panel?
But it does help us to help small businesses.
Okay, all right, and I think there's kind of two issues here. I don't think anyone debates the first 30 lines of the
No,
bill. It's
we
really
have
just the
great
last,
debate.
the offset.
It
question.
works great.
All right, I like the bill as is, it's my bill. Does anyone want to move to strike the last sentence? I don't see a motion. Unless you want to
I
make
don't
it.
know whether there's a second, but I would make that motion.
All right.
I'm all by my lonesome.
Motion dies for lack of a second. Okay, so the bill's in front of us.
Thank
We've had a pretty robust discussion. Any questions from the panel? Since it's my bill, I'm gonna move and second with Senator McClellan to report this bill.
Senator Chapin would have seconded you too.
Well, there we go. All right. All in favor of reporting, say aye. Aye. And I have McClellan and Lucas.
Let me abstain.
We've got an abstention over here. Any other oppositions or abstentions? Okay, so the bill reports with one abstention. Thank you. All right, that was 208. Okay, I think. I know you got a couple more. Ceraville is on his way. We can all rest.
Keep me busy for a couple hours.
Yeah, we do not talk to them.
They just don't have it. Yeah, they should finish.
Okay, all right. Do your thing, okay.
McClellan's bill passed with the delayed enactment.
All right, good luck.
Sorry, not for that.
I should keep it over the pen or something. If you need my book.
I don't know how long.
So sorry.
I got the wrong bill.
All right, while we're waiting on Ceraville, Senator Chapin, do you want to take a bill up?
Sure, yes, Mr. Chairman, let's go ahead and look at Senate Bill 253.
Senate Bill 253.
Yes, sir, that is the bill that comes as a result of the Supreme Court decision in possibly the ALG trustees
Okay.
back in December of 2018, a little over a year ago. And at that time, the court ruled that there were fiduciary duties owed under a deed of trust that were not contained within the contract, that there were additional duties that could be owed. And so it, in my view, it conflated and confused the issues that people, that city, people have been operating on under for a great number of years. I have been, my law firm has been a trustee for over 30 years doing these trusts. We've foreclosed, we've done a lot of this stuff throughout.
Following fiduciary duty the entire way.
Yeah, we follow that fiduciary duty as best we can in place of the contract. So, we set about trying to, in conjunction with, and this bill supported by the Virginia Bankers Association, we set about trying to, come up with a way to go back to something similar to what we thought was the rule. And so this bill, we have agreed to amend, there's an amendment too, is there an amendment?
I redid the substitute, so.
Okay.
Did you just hand that out?
Yes, sir.
Okay.
Okay, we have a substitute. Senator Lucas moves and Senator McClellan agrees to move the substitute. All in favor, say aye.
Aye.
Okay. Substitute's in front of us.
So, there's a provision there on line 71, on line 56, that we had concerns out of Fairfax County regarding restricted covenants regarding affordability. And that amendment, that part of the substitute, took care of those concerns. And then on line 71, we tried to address these concerns where there is a duty owed both under the deed of trust, and the Supreme Court says that there's also another duty owed like under a traditional trust, some other trust doctrine. And so we just simply said that the trustee, to get rid of the seemingly endless ambiguity with that thought process, we came up with an idea that if there is a dispute, as long as you've complied with the deed of trust, or the terms of this article, of the code, you're gonna be deemed to have, your actions to have been consistent with the duties imposed.
Okay.
So, we're trying to, in putting this together, we're trying to come up with some way that trustees can understand how they're gonna have closure and how they're gonna have code.
Okay, all right, that is the bill explained by Senator Chapin, Senate Bill 253, and I know you got witnesses here.
Can
We have witnesses in
Can I
fact.
just ask a question, maybe
Sure.
whether Ben or somebody, one of the witnesses or multiple of the witnesses can give me a little comfort on this. Look, this is not my area of practice or expertise. I've never done a foreclosure in my life. I'm not a real estate lawyer, but I had a law partner who did an awful lot of it, representing banks. And in my view, he was really an unusual and extraordinary bank lawyer in that he went to great lengths to advertise, to maximize the return. And very often the debtors would say, I can't believe you're this helpful to me. But he really felt that it was his job to make sure that somebody was actually trying to maximize the sales price and to be fair to the homeowner as well as to the bank. And you know, I mean, I think anybody would be lying if they said they've never seen somebody who is engaged in a foreclosure practice who just goes through the motions and really makes no effort to maximize the sales price. I mean, we've all seen that, seen examples of it. I want to make sure that this is adequate and it just isn't pulling the intestines out of the duty of the trustee to make sure that somebody's actually doing something. So, you know, most people know I'm not a bleeding heart, but I believe in fairness, and I just want to make sure that we're being fair here.
Okay, I got a lot of thoughts on this, but I'm gonna hold off. Do we have any people in favor of the bill? Yes, ma'am.
Chairman, members of the subcommittee, Demarion Johnston, Virginia Bankers Association, and yes, your concern is preserved in the bill. We have preserved the fiduciary duty that comes from the common law. It's in the substitute, and it really, I would say bases on the duty of impartiality is the one that you're speaking of, that the trustee under a deed of trust must act for both the creditor and the debtor, and that would include obtaining the highest possible price at sale. So it is maintained in the bill.
So what if there's a conflict between the fulfilling the duty to the bank and fulfilling the duty to the homeowner? I mean, how do you fulfill both fiduciary duties?
That is currently the law, and it has been in Virginia for hundreds of years, so if a particular trustee could not be impartial and serve both parties, then that trustee would have to step aside.
Okay.
Let me ask you a question. Let's say a creditor forecloses under a promissory note, which is secured by deed of trust, and you're the trustee. And the creditor provides a statement of account or an affidavit saying, here's what's due and owing. And you look at it and you just take that and you go ahead and foreclose, and you don't look behind it, you don't add the numbers up, there's a lot of soft costs in there, you don't make any due diligence investigation. You basically just accept at face value whatever the creditor tells you. And it turns out afterwards, there was a mathematical error of about $1 million. Would that be a breach of fiduciary duty?
Well, I believe there is a check and balance by the Commissioner of Accounts who has to approve the foreclosure as it's dispersed, and that is included in the bill. I believe it's included in the bill. So I don't believe that that situation would occur.
Okay, I'm sure it never will. All right. All right, do we have any other people to speak on this bill? I would be shocked if nobody had anyone else to say on this bill. Yes, sir.
Mr. Chairman, John Rust, I am the Commissioner of Accounts in Fairfax, and I have worked somewhat on the organization of the bill. If you watch the decision that had been done by the Supreme Court, Justice Mims did a really good job in his dissent, saying what was the fiduciary duty, how it was owed, and where it went. What this bill does is restored that information into the code, and I think this is very appropriate in terms of where we are. We have application of fiduciary duty between the lender and the borrower all the time in the accounts that we review, and I think this preserves that ability to do that.
Okay, thank you, Mr. Rust. Yes, sir.
I'm here to speak against the bill.
All right.
My name's Henry McLaughlin, I'm a lawyer, and I'm sorry, I didn't know somebody would call me.
That happens to me all day.
I've been practicing law for 53 years. Practicing for 11 years with my daddy in Halifax, Virginia, and then 30 years of legal aid, and I've been almost 10 years.
You can go ahead and answer. It might be a new client.
Thankfully, it stopped, I'm sorry. For the last almost 10 years, I've been in private practice, mostly representing people against foreclosures or to get houses back after foreclosure.
Sure.
I've gotten back over 300 houses after foreclosure. Wow. And almost all those people are still in their home. If this bill were the law, none of those people would have gotten their homes back. Both on the original bill and the amended bill.
Right.
Virginia has one of the fairest judiciaries in the country. We are blessed. And the Virginia Supreme Court protects the homeowner. And it's a part of a series, and this is something that cuts across political lines. I mean, I don't know whether y'all know Delegate Marshall, who's one of the most conservative legislators in the state, spoke out in favor of homeowners on foreclosures.
Mm-hmm.
I just last month had people come to me. This lady had gone out of the country because her mother was dying, and she left her fiance with the money to pay the mortgage, and he went off and did something else with the money. And she came back, and they had foreclosed. She came to me on Sunday, and I worked through a good part of the night, and she filed suit Monday morning with a list pendants, and I got an email from the substitute trustee saying that they had asked for the deed back. They'd already closed, but they hadn't recorded.
Okay.
Recorded had been too late. And they asked for the deed back, and the likelihood is she's gonna get her home back. The issue is a foreclosure that's done that is wrongful. And under the law as it currently stands, the substitute trustee has an obligation, if it's brought up that it was wrongfully done, to not allow it to happen or to set it aside if it's brought up before if the substitute trustee advertised the property being sold subject to that. And this bill would take that away.
All right.
And you would, and thank you for listening. I'm sorry it takes so long, but it really will drastically change the ability of homeowners to prevent or to set aside wrongful foreclosures, where there's a genuine issue of it not having been properly.
Thank you, Mr. McLaughlin. Okay, anybody else want to testify for or against the bill? Yes, ma'am.
Paula Sherman opposing the bill. I'm a housing counselor, formerly worked at Housing Opportunities Made Equal for 16 years, where I oversaw the foreclosure prevention program. In that role, we literally help thousands of Virginians avoid foreclosure. We often use the clause of the fiduciary responsibility that the trustee had between the lender and the borrower as a tool to stop improper foreclosures. In instances where the servicer was uncooperative or unresponsive, we would inform the trustee of such and remind them of their fiduciary responsibility. And in doing so, they would often go to the servicer on our behalf to argue on behalf of the borrower. And so, for that reason, we oppose that bill.
Okay, thank you. Yes, ma'am.
Hello, Mr. Chairman. Mariah Williams, currently with Housing Opportunities Made Equal, and for the sake of everyone's time, I'm also here to oppose SB 253 for many of the reasons just stated. We find ourselves, having to lean on our trustees' fiduciary responsibility a few times a month when our clients in our foreclosure prevention program have been sending documents and they are told that those documents have not been received. And so, you know, as we are working as an organization with the core mission of ensuring equal access to housing, foreclosure is, it disproportionately impacts communities of color. And so for that reason, amongst the other stated, we oppose this
Great.
piece of legislation.
Thank
Thank
you.
you.
Jay?
Yep, Jay Spear, Virginia Public Law Center, and we oppose the bill. The fiduciary duty is really the only thing that protects a homeowner in Virginia from a wrongful foreclosure. So you really cannot take that away. You actually have more protections being evicted as a tenant than you do as a homeowner. So please don't take this protection away. It's a big problem that our legal aid attorneys all around the state all the time have to stop wrongful foreclosures by reminding fiduciaries of reminding the trustees of their fiduciary duty. Thank you.
Okay. I just, a couple comments, and I've litigated this pretty extensively, especially in the last couple of years, and this is a very hotly contested area of the law, and Senator Chafin's exactly right. I mean, there has been a moving target for the Supreme Court. My personal view is that a trustee needs to be a referee. They need to wear the striped shirt, they need to be neutral. And they're gonna follow the deed of trust, understand that, but they also need to treat both parties equally. And I would wonder if that would be the case. Anyways, I'm one person. Is there a motion on the bill?
I'll move report it.
I'll second it.
Okay. I'm gonna make a substitute motion to PBI, and I'm gonna get Senator McClellan to second it. So, and we have a motion to pass the bill by.
Can you do that?
Yeah, no,
I don't know.
I can't second with a proxy. Huh?
For the clerk too.
Well, I mean, y'all can, I'll withdraw my motion. You sure about that?
Well, you can.
I don't have any instructions.
If you've got the proxies, you can
This
feed
is
the
Fairfax
motion.
information we'll put in there.
That's news to me. All right, we'll tell you what,
Just put the motion.
all right, why don't we have a motion to report, so, all in favor say aye.
Aye.
Okay, we have 2 ayes.
3. Tommy.
Tom Norman, okay, you've got a no from me, a no from Lucas, a no from McClellan, and you think Boy School is a yes.
I know she is. I know she is.
Okay, well, I'm gonna rely on that to say we have 4 ayes and 3 noes, and we're gonna take this back up at full committee.
Thank you, Mr. Chairman.
All right. Okay, Senator Servell.
Thank you. It's nice to escape the mess of commerce and labor. Maybe we could do Senate Bill 661. I actually have witnesses here for it, so we can take that up first.
All right, Senate Bill 661.
Yes.
Yes. Okay, Senator McClellan moves, Senator Boysko seconds, the substitute, all in favor say aye. Aye. Anybody? Hello?
Aye, yeah.
There you go. Okay, substitute is before us.
Thank you. So Senate Bill 661 is a bill to reverse a Supreme Court case in 2013 about asbestos cases. So in that case, the Supreme Court held there was a guy who had he developed mesothelioma, but before that he had a prior condition called non-malignant asbestosis. Asbestosis and mesothelioma are separate independent disease processes. One is not necessarily indicative of the other, and the Supreme Court of Virginia held that because he previously had asbestosis, that his statute of limitations began to run when he had asbestosis, even though he didn't develop mesothelioma until much later. So the problem it creates is that it creates the need to either not file over asbestosis, which is an injury, or to file then and try and stay your lawsuit forever in case you get mesothelioma, which is completely unworkable. And this bill just basically makes clear that if you file suit for asbestosis, that it's, that they're 2 separate independent causes of action, two separate, that they're not tied anyway.
Okay.
Mr. Hatton's here, and he can explain a whole lot better than me.
Yes, I'm Donald Patton.
Oh, Patton, I'm sorry.
Thank you very much. This is basically right. What we have is two diseases. One is asbestosis, a non-malignant
Right.
disease. The problem is, in Virginia, the court adopted what's known as a one disease rule as opposed to a two disease rule.
Okay.
Most states have a two disease rule, and that is, you get asbestosis, it's a non-malignancy, it doesn't kill you. That takes a very shorter period of latency. These are all latency diseases when it's involving asbestosis. You breathe the asbestos in 1975, you may not get asbestosis for 10 or 15 years, but it'll be 40 to 50 years before you get mesothelioma. However, under the current law, the way it works and where that Kaiser case ruled, which was in 2013, the court said we have one disease. In other words, you get asbestosis in the year, and we have an example. My colleague here, Erin Jewell, is a law partner of mine, and she has a case right now with a guy that cannot file a lawsuit. And the reason is he had asbestosis and what?
Our client had asbestosis in 2002. He subsequently got mesothelioma in 2017.
Right.
He died in 2018. He's survived by his wife of 40 years, as well as a minor grandchild that they were a custodian for. The Kaiser case essentially bars them from any action in court. They can't go to the courthouse. They can't file a lawsuit. This simply allows our clients who are in that unfortunate situation where they have asbestosis and later get mesothelioma.
Okay, let me ask some direct questions here. I understand this. Basically, non-malignant asbestosis or asbestos related shall not cause the action to accrue for wrongful death or personal injury.
For mesothelioma.
For mesothelioma.
For a malignancy.
For a malignancy. The actual malignancy itself has to be manifest.
That's it.
Right.
That's
All right, I get that.
Otherwise, the person who gets a malignancy, he's out of court before you even know he got sick.
Yep, I get you. Okay. All right,
I don't know if anybody opposed, nobody's come to me.
all right, well, let's see. Anyone else support the bill? Mark, just nod your head, that's all you need to do, okay. Anybody oppose the bill? Jeff, seriously?
The Virginia Chamber of Commerce opposed the bill.
Okay, all right.
Can you tell us why?
Yeah, do you wanna give us some?
They felt like the Kaiser case was rightly decided.
Okay, all right. All right, anybody else have an opinion on this? All right, you wanna make a motion?
Move to report.
Second, all right. I got a motion to report in a second. All in favor say aye. Aye. And I got Boysko, Lucas, and McClellan, aye.
You
Chafin?
for this?
I'm for this, and so is Senator Norman.
Okay, all right, so it's full house. Good work, Surabel.
Great.
All right.
Thank you for your time.
Yep, thank you.
I have somebody here in 429 also.
Do the ones where you have people here.
Yeah.
And by the way, just for people's planning, we're probably gonna come to a hard stop around 6, maybe 6:05. So just factor that in. Go ahead.
Do you wanna, any bills that you're not gonna get to, so you can have anybody go?
Let me, you plan to do class action today, I'd like to take that down the road.
Fine, okay.
All right, the bill on class action is probably gonna be heard next week. That is
1043.
10:43.
The only one I have.
And then, while I'm doing that, Deeds is Bill 285 on bystander liability is by for the year. And the Chamber of Commerce is.
One for one.
You were giving me the evil eye and I crumbled under your powers.
Thank you.
Powers there. Okay. So 285 is by for the year.
Ready?
Sorry, I should have said that earlier.
But I learned a lot. Wow.
Okay.
That was very interesting.
I don't want to hear all that on mechanics. Okay. Go ahead, Scott.
Okay, thanks. This Senate Bill 429 is a bill that you all have heard twice before. It was heard originally in the 2018 session, and the committee expressed concerns about us muddling up the law of independent contractors, and then you heard it last year, made some amendments. The bill basically would allow Department of Child Support Enforcement to do wage garnishments from independent contractors. And just so everybody's clear about the bill, this is a bill that I introduced last year. In the full courts committee last year, the then chairman asked me to delete mandatory reporting to the Virginia Hire Center from the bill. which we did, it went to the House, and then it died in the subcommittee over there after passing our body. But basically, the bill just authorizes DCSC to withhold child support for independent contractors. Right now, they can only do it for W-2 employee. And the reason it's important is a couple of reasons. Number one, and you have a couple articles in front of you which have documented that all this new gig economy stuff is allowing child support payers to not pay their child support. But there's currently about $2.3 billion of unpaid child support in Virginia. And when a recipient is forced to go on TANF because they're not receiving support, the state actually fronts the child support, and that child support then becomes owed to the state. So a lot of that $2.3 billion is money that's actually owed to taxpayers. And DCSC, by collecting it, helps alleviate taxpayer burden. I believe there's now about 15 or 20 states now, Mr. Bursham with Child Support Enforcement is here, correct me, but I think about 15 or 20 states now that do this. So we're not like treading new ground here or anything, but I think we need
Since you
to.
reminded me, is this in the form that it left the Senate last year?
No, this is in the form as I introduced it. That's basically what the bill does. Mr. Burcham's here, that's in favor of answering any questions. I think the administration supports the bill.
Okay, what's the number again, Scott?
429.
429. All right, yes, sir.
Craig Bersham, Deputy Commissioner of State Programs for the department. We do support the bill. Senator Serville's right, there's about $2.3 billion, between that and $2.4 billion. There's 16 states that have passed a similar provision. As you know, the gig economy is exploding. We're having a tougher and tougher time collecting child support, particularly from those folks who aggregate several gig economy jobs together.
Right.
And there is no provision for us to attach those wages. So what this would do is basically allow us the ability, have the employer report through the new hire like they do for any employee. So it's a process they're familiar to, and then we can send out a wage withholding and get the funds to the families.
Okay, any questions? Yep. All right, I don't really have any questions. Anybody, I've heard from support, anybody else with an opinion on this, either support or opposition? This is 429, go ahead, Track, come on.
Mr. Chairman, Rob Bohannon, representing the Virginia Retail Merchants Association. Understand what Senator Serville is trying to do, and I get the issue. The big issue we have is the broad definition of independent contractor. I mean, any individual who performs remuneration under any contract for hire, written or oral, express or implied. I mean, we take that to be if you hire someone to, paint the inside of your store, they're an independent contractor, and then you're on the hook for garnishing wages there. I see Senator Serville disagrees.
Well,
Okay, go ahead, Scott.
I mean, in theory, that's possible, but the reality of this is that the wage withholding order will only be issued to an entity that somebody knows is conducting regular business with a person. They're not just gonna send it out to the whole world and then hope money shows up. So they'll either find out that somebody's doing these gig jobs, either because the new hire center's been notified or because this child support recipient calls up DCSC and says, hey, my ex-boyfriend is working at Uber, and then DCSC will issue the order that way. But it's not just gonna issue because somebody does a random job at somebody's business.
Mr. Chairman,
Yeah.
that's wonderful. We just don't see that in the bill.
Go ahead, Senator Chapin.
Senator Serville, what's there to stop that? I mean, in the bill, I mean, what's there that would prevent someone who's just, for lack of a better description, relentless, and they're just after it, and they're willing to go to just like the job, just like what was described. Somebody, they're I understand my ex-husband's painting the house for this elderly lady over here. Here's her name and address. I want her to serve. What's going to stop it?
Mr. Bersham can talk about that, but I think DCSC has some kind of screening procedure that screens out that kind of stuff. They also have limited resources.
I think Senator, there's two things. One, it has to be $600. So if it's in the case of a single episode, I want to hire a caterer to come in and cook for my wife's birthday.
Right.
So that would there wouldn't be a constant income. We have to send out the wage withholding. So if it's a one-time deal like that, there's going to be no ability for us to attach any funds. Those funds have already gone out to the caterer, right? So it's really in an instance where you're doing business on an ongoing basis where we can notify the employer and then have them follow
I
that
mean,
process.
this is bit, I'm sorry, go ahead, Senator
So,
Chapin.
further question, so this lady has got a big house, okay? And it's got 12 rooms, and it takes a while to paint it, you know?
But
he-
that would be
he's-
one contract, Senator.
It would be one contract.
Right.
Yes.
So we would not get notice of that until they reported it, and then, so that job would be done and completed. And if we sent a wage without holding out, there's nothing else for them to attach at that point, unless they were coming back and doing multiple jobs under multiple contracts.
Okay. So basically, this is targeted at sort of the Uber, Lyft drivers, people with a consistent stream of 1099 income
From one entity.
from one entity.
Right.
Okay. Rob, you still hate it?
Well, I mean, is there some way to say, you know, it's based on, you know, 1099 income or something? We're just, couldn't find, read the bill multiple times where it was clear there. Basically, it's if you paid someone $600, they're now a part of this process. I get what Senator Servel's trying to do, and that certainly makes sense.
Is there a de minimis threshold? You said $600?
Yeah, it's
Which is
just
not a lot of money.
And that follows the IRS threshold for independent contractors. So if you hire anybody and it's more than $600, you have to report 1099.
Line 145.
Line 145, oh, you're right. All right, if we report this, does this have to go to finances or? No?
So, Mr. Chairman, one other
Yep.
Observation. So, in the world of agriculture, there's a whole lot of independent contracting going on. Like, you know, there are a whole lot of people out there building fence, people out there doing custom farming, people out there that do a lot of work. And you're gonna almost always hit that $600 plateau. You're gonna have different jobs, they're gonna be doing different things. Are we saying that this is going to apply to those independent contracts?
Sort of. First of all, I think, based on what Mr. Bertram said, if they pay anybody more than $600 a year, they're required to report a 1099 to the IRS about them, and the new hire database thing kicks in at that point. And their obligation to withhold child support only kicks in once they've been served with the wage withholding limit. So it would depend if DCSC issued the order and served them on. So that's, I think, the answer.
And Senator, I would just add to that, if they're paying their child support and there's no arrears, of course, none of this is gonna take effect. This is only where somebody has gotten behind on their child support and have to take action.
Okay. All right, committee operates by motion. I don't think Ben's gonna, I'll go ahead and move to report. Yes.
Mr. Chairman, I'm sorry, Mr. Bertram got a line
Oh, you did, okay, where?
on line 510, that last line of the bill, he wanted to strike court orders. So it would read independent contractor for the payment of a support obligation to account for administrative obligations.
Hey, what's that again?
On line 510, strike court ordered.
It's because DCSC has administered child support orders sometimes, not just court ordered.
Okay, I will move that amendment.
Voice goes seconds.
Voice goes seconds. All in favor, say aye. Aye. All right, one no.
2, 3.
It's not to report.
Okay, hold on, this is just an amendment.
Just, I mean, I'm
Just
okay
a-
with the
Okay,
amendment.
let's get to the amendment, then you can vote no. All right, so we agreed to the amendment, now the bill is before us, and clearly we've got, and I'm not totally sold on this, by the way, but I would like to move it forward at this point. I do think, Scott, you may wanna refine it so it's not every single one-off type of payment. It's more of a steady stream of income, but having said that, I'm gonna move to report. Jennifer, you're okay with seconding? To report the bill. All right, we have a motion and a second to report the bill. All in favor say aye. I say aye. I got, also Lucas and McClellan say aye, so that gives me 4. What you got?
I got 3.
Very
predictably.
All right, that bill limps out of here 4-3. Okay,
The last one.
Scott, yeah, why don't you do bicycles?
Last one is Senate Bill 659.
Okay, Senate Bill 659.
Senate Bill 659 has to do with contributory negligence when it comes to cyclists and pedestrians. And it doesn't go to full comparative negligence, but it creates a sort of a modified hybrid of comparative and contrib. So I think the committee knows that there's only 5 states left in the country that have contributory negligence: Alaska, DC, Maryland, North Carolina, and us.
Right.
And this bill was passed, this legislation was passed in the District of Columbia in 2016. And basically what it says is that if a pedestrian, cyclist, or other person on a device is injured, that their negligence is not a bar to recovery if their negligence is more than 50% of the negligence of the person who hit them. So it's not the 1% contrib rule. It's if the plaintiff's negligence is more than the defendant, then they can't recover. If the defendant was more negligent than the plaintiff, then the plaintiff can recover 100%. That's basically what the bill says. And it's also clear, I know there's always talk about joint and several and last clear chance.
Right.
That this makes clear that it doesn't affect that.
I was gonna say, doesn't this moot last clear chance? I mean, why even have last clear chance if we have this? And for those of you who are listening and saying, well, what is he talking about? This has to do with contributory negligence, where a pedestrian or a bicyclist allegedly steps or causes to be in front of a vehicle, and the vehicle then hits them. And the question then becomes, well, was the pedestrian negligent or contributory negligent to the accident? And one of the instructions you can get as the plaintiff is last clear chance, which is if you still had an opportunity to avoid the accident as a motorist, you can still be found liable.
I would think the 50% situation would trump the last clear chance in the jury's mind if they had to reconcile the two.
Yeah, I don't think you can give the two instructions. I think you gotta give one or the other. All right, well, anyone here to speak in favor? I think I see at least a couple.
Yes.
Come on over and speak in favor of this bill.
Afternoon, Mr. Chairman, members of the committee. My name is Bruce Deming, and I'm a trial attorney in Virginia.
Okay.
I'm known as the bike lawyer. 100% of my practice is representing cyclists and pedestrians, and I've been doing this for a long time.
Are you in Richmond?
In Arlington, Virginia, sir.
Oh.
Yes.